The Ontario Court of Appeal decision in Khawaja was released this morning as part of a number of decisions. There were 5 other cases. Mr. Granger and I act for Momin Khawaja, and although I have not yet been in contact with Mr. Khawaja, we're waiting to hear from him from the prison in Quebec where he is presently doing his time. Unfortunately, the Court of Appeal increased his sentence from 10 years to life. We are extremely disappointed with that result. I expect that Mr. Khawaja will be as well. In addition to increasing Mr. Khawaja's sentence to life, the Court of Appeal also increased 2 other sentences of other individuals charged with terrorism, and denied an appeal in relation to a life sentence by the defense, and as well upheld extradition proceedings against 2 other individuals. So overall, the same panel, that is the same 3 judges of the Court of Appeal, increased sentences on all of the terrorists that were convicted, and denied appeals to lessen sentences in other cases. From a conviction point of view, Momin Khawaja was convicted by the trial judge of possessing explosives for criminal purposes, but he was specifically acquitted of terrorism charges in relation to those explosives. Specifically, he was acquitted of being involved in the London bomb plot. Despite that, and despite recognizing that, the Ontario Court of Appeal has gone on to sentence him for count 1 in the indictment as if he had been convicted of terrorism, and certainly that is something that will be the basis that we recommend that the matter proceed to the Supreme Court of Canada by way of an application to leave. In terms of the conviction, the Court of Appeal disagreed with most of the trial judge's findings, but upheld the conviction in any event, I would say largely based on the content of the communications, the hundreds and hundreds of emails that Momin Khawaja sent and that were tendered into evidence. So as I say, we're disappointed. We will be recommending that Mr. Khawaja seek leave to appeal in the Supreme Court of Canada, and that's where we're at this point. The Crown, in our case, agreed with 2 for 1. We put forward 2 for 1, and Justice Rutherford, as you know, ultimately said, well, I'm not giving 2 for 1, but I'm not going to tell you what I am giving. So we're left with a sentence that we thought the Court of Appeal would at least intervene and try and give that some clarity, and they haven't bothered to do that. What they've done is increased it up to life. The big picture is you have the Court of Appeal sentencing Momin Khawaja to life on the basis of having committed terrorism in relation to the explosive devices, when the trial judge specifically acquitted him of that offense. The big picture is that you have the Court of Appeal inviting us to take it up to the Supreme Court of Canada on the issue of the interplay between freedom of expression and violence. You have a constitutional issue which has been reversed by this Court of Appeal. You have an armed conflict clause which the trial judge said doesn't apply. The Court of Appeal says yes, it does apply. The trial judge got it wrong. It was up to the appellant, or us, to prove that what he wanted to do, what Momin ultimately wanted to do, which was to go and fight and to assist the Mujahideen, to prove, they say it was up to us to prove that that armed conflict is not in keeping with the norms of international law. So putting the onus on the defense. So these are all important questions, and ones that we feel should be looked at by the Supreme Court of Canada, and we'll be making that recommendation to Momin Khawaja later today.